We didn't become plaintiff side employment lawyers because it was easy. In fact, I think many lawyers will tell you that being a plaintiff side employment lawyer is one of the hardest areas you could think to get into. And the reason for that is, we're faced with oftentimes proving intent. So what was a decision maker's intent when they selected a person for a layoff or for a termination? And discriminatory intent is obviously when it is there, it's something that also is concealed. So it's a hard thing to prove, and you need to be very diligent in how you prosecute a case in order to be successful in this sort of situation.
Yeah, when we take on a case, we, thinking like a basketball analogy, we want to put on a full court press, because from one end of the court to the other, there are opportunities to get an advantage, and we like to do that up and down. And yeah, just going on the basketball analogy, we know we can't turn the ball over. We have to be perfect the whole game, and we strive to do that.
Another way to look at it is, we have very few clients that come to us and say, I want to have a trial. Usually we have clients that are coming to us and saying, I feel like I've been wrongfully terminated. I have no income. I'm worried about my medical benefits. And they're coming to us actually to try to, hopefully negotiate a settlement if we can. The key to being successful in employment litigation is that you need to win the little skirmishes long before you get to a trial. And really that starts first with how you draft the lawsuit. We spend probably more time drafting our lawsuits than any other firm in town. And that's because we start first with the realization that behind our cases is a person. It's a husband, it's a wife, it's a son, it's a daughter, sister, or brother. And we want to tell the story of the person in the lawsuit. The other thing that guides how we draft our lawsuits are that this is going to be the very first thing that the judge is going to read. And it's critical that the judge pay attention to our case and say, you know what, this one is different than the 10 other employment litigation cases that were filed this month. Our firm's strategy from the moment that the complaint is filed and through the discovery process is to get through this summary judgment hurdle. And basically, these companies are going to be asking the judge to dismiss the lawsuit because, and essentially arguing that there aren't significant issues of fact that are in dispute and that they're going to win on the law. And so it's not necessary to have a jury trial, that the judge should just dismiss it. And many employment cases end up getting dismissed at that summary judgment stage.
With the summary judgment being kind of the be-all, end-all for the defendant, we realize that. So we're going to look under every rock, just do the best investigation we can to find out what happened. And we use interrogatories and discovery, and we use it aggressively to get to the bottom of what happened. From start to finish. And if we don't get what we want, if they've withheld something, we'll ask again. And if they don't give it to us, then we'll ask the court to make them do it. And we're aggressive during that, and we need to be.
So Ronald Reagan had a saying with respect to the Russians, which was trust but verify. In an employment litigation case, I think it's better to say distrust everything. It's just time and time again, we've found that employers will try to hide the ball once they're sued on an employment decision. So we need to probe every single contention that they've made because, they're probably hiding something. And, the other thing that's critical is to use the court. So when a defendant, for example, isn't giving us the documents that we've requested or subpoenaed, well, we need to file a motion to compel with the judge and ask the judge to force them to turn over the documents that we're asking for, because there's probably a reason why they're not turning over the documents voluntarily. Now, once we've accumulated the documents that we feel like help prove our case, we go to the deposition stage, and that's the fun part, really, which is when we're using the documents that we've found to maneuver and push the management witnesses where we need to push them or lead them in order to be successful. And it's just amazing what you can do when you have emails from 2 years ago and you're presenting those to a decision maker justifying a termination today. Now, A common gripe from the defense attorneys that we're up against is how many depositions we take. Part of our methodology of looking under every rock is deposing every possible witness that could have information that's helpful to our case.
One of the reasons we do that is because these people have information, and we hear other attorneys say, well, why don't you just talk to them, just interview them, get a statement. Well, people are far more honest when they're under oath, and we just know that to be true. And you would be amazed some of the stuff we have found out from people who the company said, you don't need to depose them, they don't know anything. Well, they sometimes end up breaking the case wide open. And another reason why you don't take their word for it, you talk to them under oath and get valuable information.
If we've done our job in the discovery phase, an employer will look at summary judgment and look at its odds in summary judgment and say, we're not going to win this. In other words, confront the reality that they're going to be defending a jury trial if they don't settle with us. And so, frankly, the majority of the time, we're able to get an employer to settle with us even before the summary judgment briefing has been completed, because essentially the writing was on the wall. One thing that we've endeavored to achieve is essentially to have our successes and the hard work that we've done for our previous clients translate into better successes and results for our current clients. And I think we're starting to see that, where the defense attorneys in town know the playbook that we use, and can consult with their client and let them know what's coming, because 9 times out of 10, the correct business decision for the company is to resolve this case early. What's startling to me is how often defendants' personal emotions can cloud their judgment, and it can take a while with us holding a mirror up to that defendant or the decision makers for them to realize that they've got a problem. The other thing we've tried to establish in town, in the companies that we've been up against, is that the longer and harder you fight us, the more it's going to cost to settle the case. It's not uncommon for, at the end of, say, summary judgment briefing, or if we've survived summary judgment, for an employer to pay a multiplier of 5 or 6 times more than they could have if they just settled when we represented a client in a negotiations on a severance package. So it's a hard job being a plaintiff side employment lawyer, but it is so rewarding. We get rewarded with hugs from our clients. We're helping the little guy against a corporation that has more money than God, basically. And that sort of David Goliath underdog scenario, I think, fits perfectly with my personality, and then Sean's personality. We wouldn't want to be anything else but representing the underdog. We love what we do. When I'm driving to work in the morning, I might be a little tired, but then I think about what a privilege I have to be able to help people that have been sexually harassed or wrongfully terminated at work. And for me to be a part of the community and to be able to do something about that is a privilege, and something that I take a lot of honor in, and I know Sean does too.
Yeah. One of my favorite parts of the job is, Josh talked about the David Goliath dynamic, and our clients are certainly on paper, the underdog, no doubt about it. We represent the underdog on paper. But when I go to work, I don't feel like it. I don't feel like I'm the underdog in these cases. And I love that, because we compete on the same stage, and we do very well. And I relish that opportunity, and I love what I do.